Yes, Mr. Shoro.
Thank you, my lord.
It's finished. Yeah, right.
Thank you, my lord. Mr. Ikiniva, let's start with a cross-examination on behalf of, or in respect of accused number 2, Mr. Ndanzi. You testified before this court that at the time when he was arrested, which was the 16th of June 2020, if I'm not mistaken, there were many pending cases against him. Am I correct?
No. Well, you're not correct when you say pending. My understanding of pending means the matter is involved. There were no matters that were involved and pending against Mr. Ndanzi. There were cases that were identified and he was a person interested in those matters. So they were not pending.
Okay, so what was the status of whatever that you have? Were they cases? What was it? So that I can be able to refer properly to those dockets. I need the status of those case dockets.
My Lord, I've said, when accused 1 and 2's name were brought to us as being involved in this matter, cold case analysis was done, and the number of cases where there were persons of interest, in other words, suspects, other than this matter, were then identified. So, but there was no pending matter, because my understanding of a pending matter is a matter that is before court. I'm answering in that context. But there were cases where he was a person of interest, particularly the one of Nongoma that Sergeant Mohani pursued him on, and others that came up, madam.
Uma nibopha umangalelo wesibini kwakade kunamanye amacala angakaqedwa la umangalelo wesibini ubekade ehamba kuwo uthi ubrigadier cha amacala awayekade engakafakwa enkantolo. Uma uthi amacala angakaqedwa, mina ngokwami ngicabanga ukuthi usho ukuthi amacala ase afakwe enkantolo, kodwa bekunamanye amacala esaphenywa kungakaqedwa ukuphenywa, hayi ukuthi angakaqulwa noma angakafakwa enkantolo.
As the court, please, we don't want to interfere with my colleague's cross-examination, but we just want to get clarity. At the inception of her cross-examination, she mentioned that she's conducting cross-examination on behalf of accused number 2. Counsel for accused number 2 has already conducted cross-examination. I suppose it might be just a slip of the tongue that was meant to mean on behalf of accused number 5, because no two counsel can cross-examine the witness for the same accused. Yes, Ms. Memshorul.
Mr. Court, please, my lord. I submit, my lord, with the due respect that I am entitled to cross-examine the witness on the evidence that he testified on.
On behalf of?
On behalf of accused number 2, as I'm cross-examining on.
Have you read the case of by Hatzenbeck, State versus who's this gentleman? The Dr. Death. What's his name, by the way? State versus Basson. Have you read that case?
No, my lord.
It says exactly what your learned colleague is telling you, that in one case you cannot have more than one counsel cross-examining on behalf of a person who is said to be accused so and so. Only one person can do it at a time in the same trial.
My lord, if the court is of the view that I should not do cross-examination to this witness, I won't have any question.
No, it's not the court. You know what? Just go to that case of State versus Basson. State versus Basson. It's by Hatzenbeck. Let's just pause and read it, because I'm now being accused that I am denying the opportunity to cross-examine. It's not me.
No, it's not the accusation, my lord. I respect the court.
Why don't you check it? So you've got a computer there, Mr. Baloi.
My lord, we don't even need to go there.
No, we have to.
Ummeli
That's a very long judgment, Maharaj.
Hello?
It's a very long judgment.
No. We just
The whole afternoon and the whole...
we just extrapolate the right. Are you aware of it?
Yes, I'm aware of that.
Am I correct in saying it says that?
Yes, Maharaj.
Unless
Yes.
there was an exception which was made by Judge Hartenbeck, because they were busy with a case which was intricate and it was voluminous.
Yes.
And he said, on the basis of that, we were given indulgence to render an exception. But generally, once a counsel is cross-examining a particular person, you see what Mr. Mcholo says? He says he's cross-examining on behalf of accused number 2. That's what you are saying, is that not so? Hello?
My Lord, if the court says I should not cross-examine, I will
No,
proceed.
you keep saying the court says. I'm saying the law says.
As the court basis.
So let's read the law. But you know what? If you phrase it some other way, it could perhaps be permissible. But if you're saying you're proceeding on behalf of accused number 2, when Mr. Ngumezulu already said that, and he knows Mr. Ngumezulu, I told him that he can't do it because Mr. Ramosipili had already done so, you remember. But I said, because we are coming into the case for an exigency of fairness, I'm going to relax that rule. And I can even do it now, but people must understand that it is not I saying that, it's the law.
As the court basis.
Just read that. In the meantime, okay, fine.
ngoba ummeli bekathi ubuza imibuzo ebuzela ummangalelwa wesibili. Manje kunomthetho owakhishwa yinkantolo, hayi ujaji mphathi inkantolo ukuthi iye yathi akunammeli ongabuza imibuzo ebuzela omunye ummangalelwa onommeli, njengoba ukuthi ummangalelwa wesibini unommeli. Manje njengoba usisi esukumela phayana uzakwethu sayofuna lowo mthetho ukuze uzofundwa naye enkantolo ukuchazisela ummeli. Uyawazi naye uthi uyawazi uma engabe inkantolo isho njalo uthi ngeke abe nemibuzo, kodwa usalinze loyo mthetho ukuze kungabi ingathi ujaji akafuni ukuthi ummeli aqhubeke.
Yeah, incidentally, Hartenbeck was a judge in this division. He retired somewhere 2000, I think 2004, somewhere there. And he was actually the most senior judge at that stage by experience, although he was not the judge president, and neither was he the deputy judge president, if I recall.
We'll check that. We can proceed on the basis that. But we can
You don't get that decision.
We do it.
So what's your problem?
It's referred to in several. We do have the decision, my lord, but we're just looking for the paragraph. There are about 4 references to the case, and we're still searching for that specific paragraph, my lord. But we just thought that to save time.
No. You can't save time by not doing the right thing.
Because we'll look for it.
Mr. Minister, you can't find that decision. On the head, no.
There are judgments, like one from Judge Begattenbeck here and one from Constitutional Court. I think
Yeah,
one
no.
normally comes in two.
Do you have both of them?
Only one that is from the Constitutional Court.
Yeah, quote it, quote it.
It confirms what
Begattenbeck said.
the judge said.
That's it. Mr. Mshonano is not aware of those judgments. Mr. Mgumuzi, you didn't read that judgment after I quoted it for you. Lika Hatzenberg.
State versus voter person.
Voter Basson, yeah.
Yes.
But in fact, that judgment goes further than what I have just said, because I am saying the general principle is that two counsels in the same matter cannot conduct a cross-examination of a state witness on behalf of a client. Here, the client is represented by Mr. Ngomezi. But the ratio in that case, it says two counsels acting for one client can't do that. They don't divide themselves. But here, as I say, there is a slight nuance in the sense that okay, I've got the judgment here. S versus Basson 2001 to SACR 537T. This matter was heard on the 30th of July 2001 by Hatzenberg R. The headnote reads like this. Fly note, trial, dash witnesses, dash cross-examination, dash of accused by more than one state advocate, dash long and complicated case concerning two separate groups of charges, cross-examination by two state advocates, allowed on certain conditions. Headnote, during the trial of a long and complicated case, the state applied before the accused was to testify for permission for the accused to be examined, cross-examined by two state advocates. The state's legal team consisted of two groups, two of the advocates handling the charges of fraud against the accused and the other two advocates handling the other charges. Whilst one group was busy with its part of the evidence, the other state advocates were not present in court. The state contended that there were in effect two separate cases before the court and that the case was an extraordinary one in which a mass of evidence had been laid. The court referred to the rule of practice which prohibits the cross-examination of a witness by more than one legal representative of a particular litigant, but held that there were some exceptions to the rule where the courts had held that they had a discretion to allow a deviation from the rule. The court was of the opinion that although the case had two legs, there was a measure of overlap. A refusal of the application would prolong the case. The court accordingly upheld the application on the following conditions. One, that the leaders of the two groups of state advocates be permitted to pose any further questions after they had finished cross-examination and his colleague had begun his part of the cross-examination. The advocates had to determine who would first cross-examine overlapping evidence, and one advocate who first cross-examined on such an aspect completed his cross-examination on that aspect, and no further examination will be allowed by the other advocate of the aspect unless substantial reasons could be provided for deviating from the rule. Actually, the gravamen of this rule of practice is to avoid a repetition of cross-examination. Like for instance, the question Ms. Michelle has asked you, it was asked.
It was asked and answered by me.
I know. I can repeat it. It was asked. Now you are being asked that question for the second time, in other words. But you know what? I'll bend the rule, do it again. You can cross-examine, but you must know that that law says that. So I take it for granted that maybe you have some information or facts which you predicate your cross-examination on. Because remember, at this stage, we are on a trial within a trial, the admissibility of a trial within a trial. And just for another legal precept, just a moment. There is a case of, and it's not me saying that, it's the law books. There's a case regarding admissibility. When issue of admissibility is to be determined, the duty of the presiding officer is to keep inadmissible evidence out, not to listen passively as the record is turned into a papery sum of appropriate to some situation. A papery sum of evidence, Frequent practice of admitting evidence provisionally, though appropriate to some situation, often works, unfortunately. The case, you can take the citation. The case is State versus Rama Valley, 1996, 1, SACR 639 AD. The judgment was written by Schultz. He was sitting with her and others. Okay. I said you can continue if you want to.
What is it?
But the proviso obviously is that if the question has been asked and answered, this judgment says I mustn't allow it. Okay.
That's a court business. Brigadier, is it correct that under the Nongoma case 136, not 136, 163/10 of 2018, which was being investigated. At the time when accused number 2 was arrested, you were not in possession, or you did not have a warrant of arrest against accused number 2.
I've answered it, my lord. On my answered, there is in evidence in chief and under cross-examination.
Yeah, that question was asked. And I think you said the person who arrested the gentleman, accused number 2, as a result of the investigations pertaining to the murder in Nongoma, was Sergeant Mohale.
Correct. In the company of Sergeant Makena.
That's it. So that question has been answered.
Thank you, Madam.
inkantolo iwufundile lo yamthetho nangokho inkantolo iwufundile ithe kulungile ummeli angase aqhubeke nangokho lo yamthetho uthi bekwamele kungavunyelwa ukuthi abuze imibuzo njengoba ummeli wakhe suka ubuza uma ebuza manje ubuza ukuthi iqiniso ukuthi ngalesikhathi niyobopha ummangalelo wesibini nanikade ningenayo incwadi egunyaza ukuthi ummangalelo wesibini abophe yaphendula ubrigadier Ruth bese senguphendulile lo mbuzo benguphendule ngithe uboshwe uSergeant Mohani ehamba no Mabena.
And until today, as you are testifying, there is no warrant of arrest that has been authorized against accused number 2 under this case.
I've answered also that, Madam.
Fikela namanje ayikho incwadi egunyaza ukuboshwa kommangalelo wesibini uthi ubrigadier nalo mbuzo sengawuphendula.
Sorry, just to be fair to Mr. Mshalo, when you in court when the brigadier testified, when asked questions by Mr. Mgumazulu pertaining to the J50s,
Yes, Madam.
that the J50s were issued for each and every accused.
Correct, Madam.
And those are warrants of arrest which enable this brigadier to take these guys to court after arresting them. I'm just saying, I listen. So there were 5 actually warrants of arrest, and we are putting it to him that up to today there was no warrant of arrest issued for accused number 2. So the evidence shows that, and I'm not giving evidence because I'm being accused, I interfere, I give evidence. The evidence which I listened to by this witness is to that effect that a warrant of arrest was issued by him, and that you applied for the warrant of arrest on application to a magistrate in Volkswagen.
Correct, Madam.
Yeah.
My Lord, maybe I referred to case 636, which is the case that you are dealing with here. But my question was...
Okay, fine.
My question was intending to ask in respect of case Nongoma case 136,
Okay, fine.
my Lord. Not the one that, Brigadier, I'm not referring to the one that you are currently busy with, which is phosphorus.
Yes, my Lord, but even that, the question was put to me by Advocate Ngomizulu about exactly the status of Nongoma 163 of 10/2018, and I've answered. It was a similar question, my Lord.
Okay.
Yebo mina ngawuphendula umbuzo ngalo leliyacala laseNongoma ebelibuzwe umbuzo bowubuzwe ummeli uMngomezulu.
And also, under the Nongoma case 289/11/2012, which is the docket that was supplied to us. Also in that case, there was no warrant of arrest at the time when accused number 2 was arrested until today.
Yes, there wasn't, my Lord.
Yelana namhlanje kulelinye icala lesibini kuleliya dokodo enasinika lona ufikela nanamuhla akukabi nencwadi egunyaza ukuboshwa kummangalelo wesibini uthi yebo ayizange ibe khona leyo ncwadi.
Same thing with the third case, which is phosphorus case number 88/06/2012.
Yes, my Lord.
Nale ncwadi nale cala leli lasephosphorus nalo alinayo incwadi egunyaza ukuboshwa kommangalelo wesibini uthi yebo.
Okay. It's fine. Let's move on to the statement that was made before Colonel Mboto. Colonel Mboto testified about the statement that he took on behalf of accused number 1. Are you following?
I'm listening, my Lord.
My question there is that looking at the time, or maybe if I can just remind you, the statement was taken on the 30th of May 2020 at 21:45.
Correct?
Yes.
That's a starting time, my Lord.
Statement sithathwe nge-30 zikaMeyi 2020 ngo-1:45. 10.
Okay. Am I correct also to say it is alleged that the accused indicated that he wanted to make the statement during the day?
Alleged by whom, my lord, that he wants to make a confession during the day? I'm not aware of it.
Iqiniso na ukuthi bekuthiwe kunamahebezi abe athe ummangalelwa bekathe yena angathanda ukugunyuluka emini uthi ubrigadier ubani obekade ena ekhuluma lelo lindaba.
Before the statement was taken by Colonel Mboto, it would have came to your attention that the accused had indicated to make the statement.
Yes, my lord, and I testified about this.
Yes.
Ngaphambi kokuthi akhulume noKolonel Mboto besese wena unolwazi lokuthi ummangalelwa bekathe ufuna ukukhuluma uthi yebo, besese ngiphane nangobufakazi balokho.
And at what time of the day did you become aware that accused wanted to make the statement?
My lord, I testify about this. I even disclosed my diary, which indicates the time when I was informed, leading up to Post-Logas meeting accused number 1 at Post-Logas outside the police station. Testified about this in evidence in chief and under cross-examination, right up to the time this confession was taken by Colonel Mboto.
Wazenini wena ukuthi ummangalelwa ubekade efuna ukuwenza istatement uthi ubrigadier mina besisengichazile lokho Nkosi yenkantolo kusukela esikhathini ummangalelwa ngizobe ngaziswa kufikela aze ayenza leso statement besisengichazile uma ngiqala ngobufakazi bami nanoma ngihlonywa ngemibuzo ngiyengachaza lokho.
Why, according to your knowledge, why accused number 1 was not taken to the magistrate to make the statement?
My lord, it was Saturday. If you look at the date of the 30th of May, it was Saturday. I met him, I think, around 1900 hours. I've testified about this. I'm not sure if you can find a magistrate around that time. So that's the first part. But secondly, my lord, commissioned officers carries the same powers as Justice of Peace insofar as taking the confessions. That is the essence of it.
Kungani ummangalelwa yokuqala yena angazange ayisiwe kumantshi ukuze ayenze istatement sakhe uthi ubrigadier uma iphendula bekade kungumgqibelo uyakhumbula ukuthi wahlangana nommangalelwa ngabo 7 ntambama la ukuthi akekho umantshi osebenzayo ngaleso sikhathi kodwa bonke ukuthi banegunya lokuthatha istatement nabo bayafana banegunya elifana nabo mantshi.
Thank you. If it is correct that the accused had indicated freely and voluntarily that he wants to make the statement, why was it necessary that it is done at night? Why didn't you wait for the following day for the accused statement to be taken?
No, but my lord, where is that regulated? There's someone who wants to confess in a complex matter that I'm seized with. He's aware of his constitutional rights. He wants to make this confession freely and voluntarily, and one makes an attempt to find an independent office, and that person is found. Why would you want to delay the checking of that? I'm not aware of a provision that says you must wait until the morning.
Manje uma ngabe ummangalelwa yena wayekade efuna ukukhuluma kanjalo ungani ke kuye kwaphoqeleka ukuthi ayenze istatement sakhe ebusuku? Uthi ke ubrigadier mina anginawo umthetho ongiwaziyo othi umuntu mayefuna ukwenza istatement kwamele kulindwe ilanga elizayo ngoba ubekade efuna ukwenza istatement kwicala elibucayi. Manje kungani kwamele simlinde ukuthi siyenzwe ilanga elilandelelayo ngoba lo muntu ufuna ukukhuluma manje kungani bekwamele simele ilanga elilandelelayo angiwazi umthetho osho njalo.
And that was Counsel Counsel to speak over you. It was in the interest of justice because it cut both ways. It's also the interest of justice that when such evidence comes to you, you must collect it as professionally and as adequately as you can to build the state's case, because that's what I was assigned with this metaphor.
Futhi ke lokho ngikwenze mina ngibheke ubulungiswa ngoba umthetho uthi kwamele kubhekwe ubulungiswa uma kusetshenzwa ngamacala.
And the accused at that time, I'm talking about the time when the statement was made, which is 2145 minutes up to 12 o'clock when it was completed, allegedly. The accused was supposed to have been sleeping by that time, resting.
My lord, I don't know how counsel knows the pattern of, I don't know the pattern, maybe I should answer this way. I don't know the sleeping pattern of accused number 1.
Lesi statement siyenziwe ebusuku ngo-10:45 ukuyofika ntathabusa. Uthi ummangalelwa ngaleso sikhathi bekwamele kube ulele Brigadier Ruth angazi ukuthi ulala ngalesikhathi.
And at the time when you became aware that accused number 1 wanted to make the statement, were you with the accused or you were informed by someone else?
My lord, I testified about this. I was cross-examined about it as well. I was informed by Sergeant Mkhula, that's what I indicated, an arrangement then we made for us to meet at Phosphorus police station. I was informed. I testified about this and I was cross-examined by Mr. Ngomezi.
Ngalesikhathi ummangalelwa efuna ukukhuluma wawukade unaye na uthi Nkosi yenkantolo bese sengichazile ngalesikhathi ngibuzwa ubaba uMngomezulu ukuthi mina ngiye ngaziswa uSergeant Mkhula ngalelicala ukuthi ummangalelwa ofuna ukukhuluma.
Is there a written statement or any written note wherein it is recorded that on such and such a particular date, accused number 2, after his rights had been explained, he indicated that he wanted to make a statement?
Well, to me, yes, it's recorded, my lord. It's recorded in my diary, and I testified about this, and I gave the copy of my diary to counsel, including Ms. Advocate Mshololo, and they read the original, which I still have. It indicated that I was informed at a specific time, what time I met the accused, the issues of rights are indicated there in the diary, and I've made the copies to the defense available.
Kukhona na la kubhalwe khona ukuthi ngesikhathi esithize ummangalelo wesibini yena ubekade efuna ukwenza istatement na uthi yebo sengishilo lokho futhi ngibuziwe nangapho imibuzo ngishilo ukuthi ngibhale kwi-diary yami i-diary ukuthi ngiye nganikeza umshushisi wanika nabameli bonke naye uMamshololo unayo.
Is there a space wherein accused number 2 signed in that entry that you made? He signed that he is indicating to you that he wants to make the statement.
Manuel, I'm not aware of that provision. I've never seen an accused that must sign in the police diary that he wants to make a statement. I've never come across that.
Kukhona la ukuthi ummangalelwa usayine khona kwi-diary yakho ukuthi yena wayekade vele efuna ukwenza leso statement esinjalo uthi Nkosi yenkantolo ngenhlonipho enkulu mina angikaze ngabona umthetho othi umsolo kwamele asayine ediary yami.
Okay, so
please, ma'am, can we get clarity? Is counsel referring to accused number 1 or accused number 2? Because she's being cross-examined.
It's cross-examined interchangeably.
Now she's referring to accused number 2. If we can just get clarity.
Yes. Earlier she said accused number 1. Now she's on number 2.
my lord, the statement that was made to Colonel Mboto is for accused number 1.
Yeah, I'm just answering your learned colleague.
It's for accused number 1, the statement that was made to Colonel Mboto.
Yes, go on.
Thank you. Whether you know the procedure or know the procedure, I just wanted to know that there is no way wherein he acknowledged or he signed the entry that you made in your diary.
No, but this witness says there is no such procedure. So if you know the procedure, put it to him so that we make progress. That the procedure dictates, or the law dictates that.
As the court pleases, my lord. Brigadier, is it not the procedure that when you are conducting interview with the suspect, you will have a pro forma in front of you, wherein when you follow that pro forma, I think we are familiar with that, you will explain the allegations, the constitutional rights, and then you will record the response given by the accused after the allegations had been explained to him.
My Lord, counsel is referring to a warning statement. That's what you're referring to. There's a difference when you meet someone on the street, whether we're executing the warrant of arrest. There's never been a situation, my Lord, when you're carrying a warrant of arrest. simultaneously you will carry the interview form and say, this is the warrant of arrest, I'm arresting you, now I must take you through the warning statement. It doesn't work like that. That's not how it's supposed to be done. You meet the person, first is the arrest, the constitutional rights in terms of what he is entitled to, you deal with that part. Subsequently, when the detention and the time to prepare the person for court, that form kicks in. But you can never make an arrest and simultaneously at the time when you're making an arrest, take the person through the warning statement. It's not doable.
Uthi ke ummeli incwadi le eyemibuzo ube ukade unayo njengoba wawukade uhlangana nommangalo lesibili ubrigadier uthi ayikaze yenzeka empilweni solobo yena kuyiphoyisa la ukuthi uthethe incwadi egunyaza ukuboshwa kwamsolo bese kuba nale yemibuzo uthi cha ayenzeki leyo kuyaye kube nokuthi umuntu kube nale ncwadi egunyaza ukuboshwa kwakhe bese atshelwa amalungelo wakhe kodwa leyo ukuthi yokuhlonywa imibuzo kaningi akusincwadi ukuthi unobanokuthi bayiphathe isikhulukazi uma behlangana nomuntu emgaqweni.
I put it to you, Brigadier, that is this procedure, that is the standing procedure by SAPS that whenever we are conducting an interview, or not necessarily that whenever an interview is being conducted with the suspect, immediately after he has been arrested, when there is interview that is conducted, it must be recorded. And that form is assisting to ensure that the constitutional rights of that person are not infringed.
No, but I disagree, my lord. Counsel is talking about the product that is at a later stage. It's well known, my lord, that people get arrested with or without the warrant, even by uniform members on the street. Those members who arrest them on the street, they don't carry warning statements. They will arrest them on the allegation that is before them, or the evidence that is before them, take them through the holding cells where they are processed on the SAP 14, 14A chart and check them. Then the investigating officer will come either on that day or the following day, then take them through the warning statement. But by the time the warning statement kicks in, police have already dealt with them in terms of the arrest, and question may have arisen. They would have even maybe followed alibis in terms of what they are saying or followed certain information. So that is not correct that when you arrest a person, that form must simultaneously kick in. That's not how we stand.
Uthumeli ke mina ngiyacebisa ngiyakwazisa ukuthi umthetho wesiphoyisa ukuthi uma niyobopha umuntu incwadi leyo kwamele ibe khona uthi cha akwenzeki ukuthi namaphoyisa nje uma baya bayobopha umuntu bangaba nayo incwadi egunyaza ukuboshwa kwakhe kodwa le eyemibuzo akuvamisanga ukuthi babe nayo ngoba bafika bambophe lo muntu loyo bese uyabuzwa ke imibuzo aziswe namalungelo wakhe. Leyo ncwadi leyo inokaningi iyaye igcwaliswe ngemuva uma seyikuthi lo muntu loyo kuhlelwe phansi naye kodwa uma kusayiwa kuye akusuka ukuthi kuvamisile ukuthi ibe khona leyo ncwadi.
Furthermore, also, my lord, I can just add, sorry, counsel, that even when the person is arrested for the first time, his or her constitutional rights are explained to her. But the formality of those constitutional rights, my lord, kicks in at the holding cells when the SAP 14A is completed. So it doesn't mean that when the 14A is completed at the holding cell, it is the first time the person is being made aware of his rights. When he's arrested, it's a procedure that he must be warned according to his constitutional rights, but no form. No one goes around carrying the SAP 14 form, my lord. Same with the warning statement. That is done at a later stage.
Futhi ke kuyayenzeka nokuthi umuntu acebiswe ngamalungelo wakhe uma eboshwa ngaphandle emgaqweni bese ithi uma esesemaselini uma ezocebiswa futhi ngamalungelo wakhe bese kula kugcwaliswa lencwadi le alikho iphoyisa elihamba liphethe incwadi emgaqweni.
Let's leave that for the argument, Brigadier. Let's move forward. Is it also correct that you asked Constable Monare of Metropolis Egoruleni to accompany the team that was transporting accused number 1 on the 30th day of May, when specifically he was taken to Cannon Board?
Yes, I've dealt with this matter.
Okay.
Manje iqiniso na ukuthi wena brigadier uye wacela uKenel Munareng, iphoyisa uMunareng lo wasebenza eGuruleni Metropolis ukuthi ahambe nomangalelwa njengoba bekade kuyiwa kuKenel Mbotho uthi bese senguphendulile lo mbuzo.
And what I want to find out from you is the instruction of the duties that you requested Constable Munareng for.
My Lord,
Because he testified that he was asked to give protection to the team. By team I mean the SAPS members. So as Metro he was asked to give escort to the team. That's why I'm asking you to clarify for me that what is it exactly that he was asked to do at that time when accused number 1 was taken to Mbotho.
My Lord, I dealt with it. I was cross-examined about it. I testified about it insofar as the evidence in chief is concerned. I dealt with it, that I phoned him, we met, I handed the accused to him, explained, I've dealt with it, my Lord. And questions were put to me and I've answered.
Yeah, can you answer my question? Because I want to know what is it that you asked him to do.
But
specifically, Constable Munareng.
I've answered, Counsel.
Are you refusing to answer the question? You are a police officer. We are a member of the police officer. You are bound to repeat this answer and answer my question. What is it that you asked specifically other than what he said in this court?
Well, my Lord, with greatest respect to Counsel, I'll repeat it again. I've said, I asked Constable Munareng to assist with the escort of accused number 1 from the provincial office to Mbotho. They were not involved in that regard. Subsequent to the completion of the confession, I further asked him to escort the investigating officer insofar as the matter of accused number 1 is concerned, Sergeant Mukola, with what he needed to do up to the time that they were detained. That is insofar as my activities with Constable Munareng. I testified about this in evidence in chief, and I think I've dealt with it extensively also during the cross-examination. So it's a repetition, my Lord, of what I've said.
Uyaphinda ke ubrigadiri ubufakazi obekasesekaphane ngabo uthi uchazile kuMunareng ukuthi ahambe neqembu lakhe njengoba kwakade kuhanjiswa umangalelo oqala kuKenel Mbotho bese ayabuya aphinde ahambe neqembu lakhe abashiye la ukuthi bebakade bazoyisa umangalelwa khona aqhubeke ahambe no Sergeant Mukola la bekade eyogcina khona.
The statement which was made to Mbotho was taken at the police station. Do you understand that, Brigadier?
Yes.
Was taken at the station.
I'm listening, my Lord.
There were members of the SAPS at the station at that particular time. My question is, why was it necessary for Constable Munareng to escort the accused to Mbotho when there were members of the SAPS who could have executed those duties?
But that's not how it works, my Lord. When you ask someone to take a confession, someone must do the handing over. So for that to happen, it means I would have had to speak to someone in Dikloof who can assist me with that. I didn't have anyone. I didn't know anyone in Dikloof. And Dikloof police station was chosen by Mbotho, not by me. He said the sample can be brought into Dikloof. So I didn't know anyone, my Lord. But the process is such that the person who wants to make a confession must be handed over by a member, so that then the officer that is taking the confession will indicate who handed that person to him. It's a procedure.
Ngoba bekukade kunamaphoyisa la umangalelo wayekade eyisiwa khona ukuyoyenza lesa statement, kungani uye wacela ukuthi uMunare ahambe nabo? Uthi epolice station yaseDikloof mina ngangikade ngingazi umuntu, manje bekuyofuneka ukuthi kutholakale umuntu ophakathi lapha epolice station yaseDikloof. eDikloof nayo ipolice station leyana uKenel Mbotho othe umangalelwa alethwe khona. Mina ngangikade ngingazi umuntu, manje uma umuntu efika epolice station kwamele anikezelelwe ukuthi nangumuntu simletha la, ingakho ngingacela ukuthi uMunare aye ayonikezela ngaye umangalelwa wokuqala.
Okay, let's move on. Thank you for that answer. Brigadier, am I correct to say, at the time when the statement was taken by Kenneth Mboto, Kenneth Mboto was not part of the investigating team, and he was called by you, and you are the only person who had facts, information of this case docket that you are dealing with today at that time?
No. So it's correct that Kenneth Mboto was not part of the investigation, I agree, but
Yes.
to say I was the only one who was aware of the facts of this investigation, that's not correct. I've indicated, my Lord, that it was prosecutorial driven investigation. So I was not the only one, and part of the investigators also were privy to what is contained in the docket. So I was not the only person who knew about the docket.
Let me rephrase it, Kenneth. So maybe you did not understand it. I'm sorry, not Kenneth, Brigadier.
You don't understand the question, sir?
I understood the way she asked me, my Lord,
Okay.
and I've answered it that way.
I was saying between you and Kenneth Mboto, at the time when the request was made, the only person who was privy with information and facts of the police docket, it was you. That's what I meant.
No, I disagree with you. You're talking about the facts of the docket, and I'm saying to cancel, my Lord, a lot of people knew, including the prosecution. That's why I indicated it was a prosecutor-driven investigation, including crime intelligence and part of the members of the team. So we brainstormed. When the docket was given to us, I've indicated, my Lord, that cold case analysis was done. When you analyze, you dissect. So issues of the docket were not known only to me.
manje ke uyakuvumela ukuthi ngalesikhathi uthumela ummangalelwa ku Kenneth Mboto wakade kuwe wedwa owaziyo ngaleli cala ubrigadier uya uthi cha besingasiyimina kuphela ngoba njengoba sengishilo ukuthi besiphenya simfuna nokushushisa ingakho ngithi bebakhona abanye abaziyo thimba lami abashushisi nabo besesebazi bekuyiqembu ebelikhona elaziyo akusimina ngedwa obekade eyazi ngaleli cala.
So are you suggesting that Kenneth Mboto knew about this case when you called him?
No, but my Lord, that's not what I said. I've answered this question really with due respect to counsel earlier, that I agree with the notion that Kenneth Mboto did not know and was not part of this investigation. The second part of my answer relates to me being the only person who knew about the docket, and I'm saying prosecution knew about it, members of my team knew about it, all stakeholders who were playing a role in this matter knew about that matter.
Akusimina uKenneth Mboto wayekade engazi futhi sengichazile lokho ukuthi wayekade engazi ngale cala bekade kunabanye engisebenza nabo nabashushisi uKenneth Mboto yena wayekade engazi ngale cala.
I can see we are avoiding the answer. Let's move on. I'll move on to the evidence of Constable Tapelo Onarenga.
That's a good question. Can be specified in which respect the witness is avoiding the answer, because he has answered to the question.
Yes, Ms. Mboto. Solon.
My Lord, it's because, my Lord, it was even put, the question was put by this court on the transcript, if I can just clarify the background of where I'm coming from with this question, my Lord. On the appearances of the 13th of October 2023, under the questions by court, my Lord. The question was put on page 81 to page 83 under the questions by court to say, at the time when you called Kenneth Mboto, you are the one who was in possession. Sorry, my Lord. You were not in possession of the police docket.
I would never ask that question, but not me.
My Lord,
Listen to the evidence as I understand it.
let me just...
The brigadier testified that after having consulted or interviewed accused number one
Subject number one.
at Rhoqo.
That's phosphorus.
Sorry, phosphorus. Yeah, confusing with number two.
Yeah.
When he said he wanted to make the confession, you said to him, if that is so, you will find him an independent
Person.
Correct.
police officer, who shall take your confession? And then as they were going wherever, you phoned
Correct, my lord.
to say to Mukhano.
No, I phoned various individuals.
Yeah, but you phoned several, and then the only person who you could get was Mboto,
Correct, my lord.
right? And then you advised Mukhano, is it?
No. On this one, I advise Munare, my lord.
Oh, sorry.
This is here. Constable Munare.
That's it, sorry.
Yes.
That
Yes.
this taking of the confession has been set down before Kenny Mboto at deep proof.
Correct, my lord.
And you say thereafter, at that particular time, you handed over the accused to them to take to Mboto.
Correct, my lord.
That's how I understood the evidence.
My Lord,
Now, how would I say he didn't have the docket and blah blah?
my Lord, can I just read the line as is, my Lord? It's on the transcript dated 13 October 2023,
Yeah.
on page 81, my Lord, line number 20.
Right?
My Lord, it says, did you have a docket with you, sir? And then the answer says, no, my Lord, which you were given by Gininda. That's the question asked by court. Then the answer says,
So I wasn't asking Gininda.
no.
Who was I asking?
My Lord, I had said the
No.
question,
Who was I asking?
the question was put to Colonel Mboto. It's the
Oh,
question
yes,
to
fine, yeah,
Colonel
fine.
Mboto. Yes.
Yes.
About Colonel Gininda.
Right, yes.
Yes, my Lord.
And I asked him if he had the docket.
Yes.
Because if he said yes, that was the end of the taking of the confession, because he's not supposed to be in charge of the docket, because it's assumed not to be part of the investigation, and it is assumed that he has no indication or knowledge about the investigation of that case.
Of the case.
Can we make progress, please?
Yes, my Lord. So my question to you, Mr. Gininda, is that at this time, the only person who had information about the police docket for the statement that was taken to, it was yourself, not Colonel Mboto.
But no, Lord,
But yeah, no, I thought this witness says this was a prosecutorial-driven exercise. They were having meetings and they are part of a team. And so it was not exclusively himself that was privy to the information which was in the docket, because they worked as a team. Is that what you're saying, sir?
that's exactly what I said, my lord.
uthi ubrigadier bekade besebenza bayiqembu, akusuyena yedwa obekade ebone noma enolwazi lwedokodo, ubekade besebenza bayiqembu.
Let's move on. I'll leave that one for argument as well. Let's go to the statement that was made on the 24th of June. It's Exhibit JJ, my Lord, to Ms. V. Cormier. Ms. Cormier testified. I know you were not here, but I'll just refer you to what she testified and what she wrote outside this pro forma. That there were heavily armed police officers that she found outside his office. Do you understand that?
I do understand.
Uthi ngiyazwisisa ukuthi uthe uMamkronye ukuthi uthole amaphoyisa abekade ehlomile ngaphandle kwehhovisi lakhe.
According to your knowledge, how many police officers you had instructed to take the accused to Ms. Cronier?
No,
This
ma'am.
is, my Lord, sorry, this is accused number 2 now, who made the statement to Ms. Cronier.
My Lord, also this part I've covered in my evidence in chief, and I indicated, I'll repeat it again, my Lord, that I did not designate specific number of protectors. I only spoke to Sergeant Mukhana to arrange the movement of accused 2 from the police station to Boxford, the magistrate court. He then, I'm aware that he made a use of SWAT or escort, but he coordinated that. I've said this, my lord.
Manje wena brigadier wawukade uhlele amaphoyisa ayingakhi uthi mina ngokwami ngikhulume nje noSergeant Mhlani ngathi ayise umangalelwa eBoksburg enkantolo. Yena ngiyazi ukuthi uyena oye wahlela abantu laba abeSWAT ukuze bazomnceda. Ukuthi bebangaki angazi.
Ms. Kronje also further testified, we'll comment if we do have the answer. Ms. Kronje also testified that he asked these members to produce their pocketbooks, and when she asked those members to produce their pocketbooks, they disappeared.
Manota was not there. I can't comment on this. I don't know what to say. I was not there.
Uthe uMantu Kronje uye wacela namaphoyisa ukuthi bakhipha ama-pocketbook wabo bona bagcina seyikuthi bayanyamalala khona lapho. Uthi brigadier bengikade ngeke ngikwazi ukuphendula lokho.
Before the accused was taken to Ms. Kronje, it is the evidence tendered before this court that he was firstly taken to Colonel Brapajo on the 19th of June, which was before the making of the statement to Ms. Kronje.
Yes.
Are you following?
Yes, my lord. And I've testified about that as well.
No, just wait. Don't rush. The evidence in terms of the OBs that have been presented before this court is that, or maybe I can just refer the witness to be quick, my lord. To Exhibit MM. I've asked the state to arrange the OB book for Exhibit MM because I just want you to comment on the entries there.
Which OP is this concern? For which police station? If something assist.
I've asked the state to arrange that OB for the 19th.
To the north, my lord.
Yes, I do have the 19th, the OP of the 19th of June 2020.
Yes, the 19th of cross-reference 531. I'm not sure it's 531 or 537. You see that one?
Yes, I see.
Yes. The one for 230. Which is 520. I don't know which one is the correct serial number for that entry. Maybe you can assist me there. Because there are two.
So 531 is the one for 230.
For 230.
Yes.
And then 570 is the cross reference. Or 520.
No, so 530, my lord. 531 is the one where the arrival time is 0230.
Okay.
Yes. Which one you want me to assist you on with?
And then this one, 520, is the cross reference.
It's the cross reference of that one, yes. This is investigation back, so the 520 is when he was booked out.
Okay. Then let's deal with that. It shows, my lord, this entry has been placed on record before. I'll just put the question straight to the witness. This one indicates that the accused was booked back at 2:30, and then down after the same entry, which is entry number 532, he was booked, he was charged. And then if you go to entry number 534 of the same date, are you following?
I'm listening, my lord.
534 at 4:50. The suspect is transferred, prisoner transferred, Sergeant Mohane of National Court Case, suspect murder on murder case 163, Bongani Dance. In a nutshell, it's a booking out of Bongani Dance at that time. Do you see that one?
I see that, my lord. That's,
yes.
That's what the OB reflects.
Yes.
Uthi yebo yakubona lokho kubhaliwe kubhalwe kwi-OB
And the further entry says, transferred to Phosphorus Court without any injury or complaints. Correctly transferred.
Yes, I see that, my lord.
Uthi uyabona ukuthi kubhalwe ukuthi umsolwa utransferelwe esiphoyiseni esasefosforus engenazo impawu zokulimala.
Okay. So it means this suspect is booked out at this police station.
That's what the OB means, my lord.
Yes.
Uthi i-OB ibhalwe kanjalo ukuthi lo muntu utransferiwe.
And according to the evidence of Sergeant Mohani, is that when he was booking him out here, they intended taking Mr. Ntanzi to Phosphorus Magistrate Court. However, on the way, they received a call from you that they must go to Moroka Police Station for the accused to make a statement before Colonel Rapad. You correct me if it's not the correct facts.
No, it is correct.
It is correct.
That I made arrangements with Colonel Rapadu. I'm just
Yes.
not sure about the time, but at some stage, yes, I would have informed Sergeant Mohane that
Yes.
they must take accused to Colonel Rapadu in Morocco.
Yeah.
Yebo iqiniso ukuthi ubekade uSergeant Mohani yena ehambisa umsolwa wesibini Moroka eFosloras ithema balibele bahamba kula ukuthi wena brigadier uye wamshayela ucingo ukuthi amise eMoroka uthi yabona ngokho ngeke ngikhumbule isikhathi kodwa kunjalo ukuthi mina ngiyengamshayela ucingo ngathi amiye naye eMoroka.
Okay. Did you tell them where to go to with the accused, where the statement would have been taken?
Yes, I told him, and then I gave him Sergeant Mohane now. I also gave him the number of Lieutenant Colonel Rapad. I've testified about it, my lord. That I've then connected him to say this is the colonel that will assist you, and these are the cell numbers for Lieutenant Colonel Rapad.
Wena uye wakhuluma naye uSergeant Mohane umazisa uthi yebo ngeke ngakhuluma naye futhi ngamnika nocingo namanombolo wecingo luka Sergeant uColonel Rapadu ukuthi nawa nangumuntu ozokusiza njengoba uya lapha eMoroka.
Did you tell Sergeant Mohane to which police station should they go to, or they decided on their own?
No, my lord, I did, and I've said this. I don't want to be seen as if I'm running away with the answers. I've testified about it in evidence in chief, dealt with Mr. Mgomezulu, and I've just said it a few minutes ago, seconds, my lord, that I did tell them that they must go to Morocco ECPS.
Mina ngibatshelile ukuthi kwamele baye esiphoyiseni saseMoroka uSergeant Mohane uthi bese sengiyichazile leyo nto nanoma ngibuzwa imibuzo ummeli uMngomezulu.
And then, where is the OB entry for the Moroka police station as proof that he was taken to Moroka police station, wherein during that detention the statement was taken?
No, but it is incorrect that he was detained. When we talk about detention, we're talking about incarceration. He was not detained there. And the making of the OB, my lord, when the confession is taken, it's something that the police officer who takes it may decide to keep record. It's not a requirement that when you take a confession at a particular police station, you must necessarily make an OB entry. Colonel Mboto chose to make one. I think there was one that was made by Lieutenant Colonel Hadebe in Albertine. In Morocco there was none that was made, but there's no regulation that says you must make one. So that's the first part. But the second part, my lord, accused 2 was never detained in Morocco, so it's not correct to say he was detained there.
Asilona iqiniso ukuthi ummangalelo wesibini uye waboshwa noma wagcinwa eMoroka uthi akulona iqiniso lelo manje indaba yekubhala umuntu obhalayo uyena ozikhethelayo awukho umthetho othi kwamele uma kunomuntu ohlangana naye ukhuluma naye njengephoyisa bese uyabhala kodwa umuntu obhalayo uyaye azikhethele yena ukuthi abhale ukuze aze abe nalezo zinto ekuthi zikhulunywe.
I differ with you, Brigadier, with due respect. The procedure in the SAPS is that when a person is taken to the station, he will be booked into the books of the station. However, we have given the explanation that we have given to the court. in light of what we have said to the court, that is not a procedure, it's not a requirement, where is proof that this statement was taken at the time when the accused was at Moroka police station?
My Lord, I'm not aware. I think I'll deal with the answer to this question lastly. That's why if you look at the pro forma, in terms of what I'm going to say, my Lord, the pro forma for confession, there's not even a portion where you must insert an OB entry on that pro forma, because it's a guideline of what questions you must put and what answers you must give. There is no portion where you must give detention OBs and SAP 14. It's simply the practice that other officers will prefer to say, let me make this entry and document in the OB what transpired. Now that's the first part. The second part, my Lord, if counsel says there is a procedure in the ACPS, please can she just advise me on this, because I'm not aware. There's no such standing order that says when you take a confession, it must be documented at the police station. What counsel also must know, my Lord, when you take a confession, it doesn't necessarily mean it must be at the police station. You can be called to this court and use one of the offices and document and take the confession, the written down confession. There are no detention cells here. Where will you record the occurrence book? The guideline is the form, but then in terms of best practice, other officers will say, let's make an entry so that things are seen to be, some record that things were done in a way that suits him, and it will make things up for him or her when he testifies before court.
Chike ummeli uphi ubufakazi obubonisayo ukuthi lesi statement senzelwe eMroka, ngoba ucebisa ubrigadier ukuthi umthetho osho njalo ukuthi uma uyiphoyisa kwamele kuboniswe ukuthi lento le ewuyenzile yenzelwe kuphi, statement lesi siyenzelwe kuphi. Ubrigadier uyaphika uthi istatement singayenzelwa nanoma kuphi, nala enkantolo umuntu angase abizwe afakwe ehhovisi elithize abuzwe imibuzo, futhi akawazi noma awukho umthetho oshoyo ukuthi kwamele kubhale. Umuntu uyaye abhale yena ngokwakhe ngokuthi azenzele ukuthi uma kungenzeka ukuthi kudingeke ukuthi azobuzwa bese yena uzibhalele, kodwa akusuka ukuthi umthetho wesiphoyisa uthi kwamele ubhale wena uma uthatha isikhathi.
Thank you for that information, Brigadier, but be that as it may, whether best practice was followed or procedure was followed, whatever the privileges the SAPS have, my statement, or what I'm saying to you, is that there is no proof before this court that this statement was taken at Morocco.
Well, my Lord, I think Lieutenant Colonel Rapadu is best vested to come and testify on these issues. The form indicates that it was signed at Morocco police station. There's a date, there's a time, there's a starting time and ending time. If then that is in dispute, I think Lieutenant Colonel Rapadu can best deal with counsel, my Lord.
Uthi ummeli abukho ubufakazi obubonisa ukuthi lesi statement sithathelwe eMroka police station, kodwa uthi ubrigadier ucabanga ukuthi umuntu ongaphendula lo mbuzo kangconywana kungaba uLieutenant Colonel Rapadu, ngoba lesi statement sibhale isikhathi ukuthi uqalwe ngobani isikhathi, siphinda siyabhalwa nokuthi sithathelwe eMroka ngobani isikhathi, kwaqedwa nangobani isikhathi. Yena ucabanga ukuthi Lieutenant Colonel Rapadu yena umuntu ongase eze ezophana ngobufakazi baleso statement ukuthi sithathelwe.
Thank you, Brigadier, with that answer. Let's move on now to the assault that was reported by accused number 2 in court, that he reported that he was being assaulted in a Silverton police station. You remember that portion of evidence?
I don't remember to say he was assaulted.
Actually, accused one, my Lord.
Accused one, my Lord.
Oh, thank you, my Lord. Sorry, my Lord. Can I just clear the instruction, my Lord? Thank you, my Lord. To correct the statement I've made, it is in respect of accused number 1 who reported the assault. Brigadier, my apologies for that. I'm referring to accused number 1.
Accepted, yes.
Is it correct that that information or that complaint about the assault was related to you as the head of the unit?
No, but that's not correct, my Lord. I also dealt with this part. I mean, we also read the charge sheet that no names are even. I even went insofar as saying the document speaks for itself, and that was when it was put by Mr. Ngomezulu that these are the people who actually assaulted accused number 1. My name was not mentioned there, but even then I said in the charge sheet, insofar as the charge sheet is concerned, the presiding officer did not mention any name except that it's SAPD Silverton. That's how we dealt with it, and that exhibits it's clearly stating what I'm saying.
Kuthi-ke akukho la ukuthi kubhalwe amagama, inkantolo nje ebhale ukuthi SAPD Silverton, namagama lawa akhulunyiwe, igama lika brigadier alikho la lichazwe khona.
Maybe let me clarify it. I never said the reference was made about you. I said the information was related to you about the assault.
No, sorry. That's not the evidence before this court. The evidence before this court is that Sergeant, the lady,
Sergeant
Mohola, was told that accused was assaulted at Silverton police station, and this is the time of COVID.
Correct.
Right. Then he reported the exigency to you that I have a report which says accused number 1 was assaulted at the police station in Silverton.
Correct.
I don't want to give evidence. And then obviously the concatenation of events is that he, Kininda, said to Mahanu, go and interview the gentleman and assist him to lay a charge of assault, and the evidence says they refused. Am I correct?
Thank you, madam. Exactly what I'm relating to the witness, madam.
No, that's not exactly what you're relating. It's me relating the evidence of the court.
The information about the assault was related to you by Sergeant Mukholi about the assault.
So that I was informed that accused 1 is alleging that he was assaulted.
Yes.
I was informed.
Yes. By relating, I mean the message was conveyed to you.
Yes, that's what I meant.
You agree with that? Okay.
I agree with that.
And in terms of the procedure, if there are any allegations of assault by members of the SAPS, the people who are supposed to investigate that complaint is the IPID, which is the Independent Investigation Unit.
No, but that's correct, my lord, but that does not prohibit police officers to do preliminary investigations. IPID, from time to time, a case will happen, it gets registered at the police station. Once you are sitting with a docket where you realize there was violation of rights by police officers, you then refer the matter to IPID. It does not mean that when someone comes and alleges that I was assaulted by the police, before you even take a statement, you now refer that complaint. That is a complaint. Referral of dockets by IPID, it's when there's a registered docket, a formal complaint with a statement under oath that alleges that police officers have done 1, 2, 3. Then, that is why I said to Sergeant Mohola, once this has been done, register the docket, bring it to me, because then my decision would have been to refer the matter for further investigation with IPID, my lord. So we did not even arrive there because accused number 1 refused to make a statement. I made my own inquiries right up to prison, and there was no proof that there was such assault.
Uthi-ke umeli uma kunesikhalazo ukuthi umuntu ushawe amaphoyisa, abantu akwamele baphenye ngalelo cala abaphenyi abazimele ababizwa i-IP. Brigadier usekayachaza ukuthi kusebenzeka kanjani-ke ukuze liyofika ku-IP. Uma umuntu athi ushayiwe kwamele kuphenywe, amaphoyisa nalo anegunya bokuthi bangaphenya bese banika obaphethe. Yingakho yena ubrigadier uye wathi uSergeant Mukhola aye ayophenya ayozwisisa ukuthi kwenzakeleni bese aletha idokodo uma ingabe lizovulwa alethe kuye yena ukuze azolithatha alise phambili ukuthi kuphenywe. Kodwa impendulo ebuyile ukuthi ummangalelo wokuqala yena azange amnike ulwazi oluphelele noma akazange afune ukuchaza ukuthi ushawe akuba.
So this case was not reported to IPID for the IPID to investigate it further, those members?
No, but what case, my lord? There was no case. That's the point that I'm saying. You have to have, for the case, counsel knows you have A1, what you call in the docket, alleging what the allegations are. Then subsequent to that, the docket will be registered. Then the referral, my lord, when police members are implicated, kicks in. Or if there are some issues with restriction of the docket, but at least when we have a formal complaint, you can then deal with the referral to IFID. But you cannot refer something that preliminary investigation clearly indicates that this is not true. How do you? There's no case there, my lord.
manje nje lelo cala alizange lona lithunyelwe kulabaphenyi abazimele ubrigadier uthi baphi liphi icala ngoba akuzange kube necala elavulwa manje belizoyiswa kanjani kubaphenyi abazimele kungenacala elivuliwe ngoba kuyiswa nje amacala avuliwe kulabaphenyi.
My Lord, with the leave of the court, can I ask to pause here? It's 15:20 now. There is too much heat where I'm standing. The aircon is not functioning, my Lord. I want to now move to the cross-examinations on the ABS and that evidence of those witnesses in respect of ABS. Yes, my Lord.
Mr. Baloyi.
My Lord, the court, if I may also report, the aircon is not functioning in this. If we can be assisted, my Lord, in that regard. Thank you, my Lord.
Should we adjourn, sir? Are you available, Brigadier?
I am available, my lord.
Okay, the court will adjourn until tomorrow.